I graduated from University of Nebraska College of Law in 1977. I moved to Ogallala, Nebraska. I went into private practice in a firm there. After a few years, I went into a different firm with a sole practitioner who was also the Keith County county attorney, and I became a deputy county attorney. Did that for a while, and then I moved on to the largest firm in Ogallala and practiced there for a number of years. We moved back to Lincoln. I went to the U.S. Attorney's Office as a Deputy United States Attorney. There was then a vacancy on the District Court bench in the 3rd Judicial District. I was appointed by Governor Orr in 1987 to the Lancaster County District Court bench and served a little over 26 years, retiring at the end of March 2016. You know, for 26 and a half years, I really enjoyed serving the people of Lancaster County as a district court judge. Probably one of the most rewarding things I ever did was be involved in the Lancaster County Adult Drug Court program for going on 13 years. Because not everybody is successful in the program, even if you try everything you can to get them successful in the program. But whenever you have a graduation, there's just almost nothing higher than that. I also have been very rewarded by thinking that I have been able to provide people an opportunity to say what they want to say as long as they follow the rules. I personally believe that self-represented litigants are going to be a major impact on the trial courts in Nebraska over the next decade. They have been for the last 5 to 7 years, and I don't see anything other than that expanding. Along that same vein is what's called the limited scope representation program for attorneys that we see, when I say we in the district court level, see primarily involving domestic relations divorces. And there are attorneys who register to do limited scope representation, and I think that's a lot different than it was just even 5 years ago. And I see that expanding tremendously. The courts are becoming, or attempting to become, much more accessible to the self-represented litigant. I have always wanted to do my job the best I could. I've wanted to be fair to people. Obviously, when you have to decide cases, there are always somebody who doesn't think you're fair. But it's been my goal to be fair, to allow attorneys, parties, to have an opportunity to say what they wanted to say, again, provided that they adhere to the proper protocol. And then to try to make a well-reasoned decision based upon the information I had and the law as I believed it to be. Judge Chevrant was a district court judge in Lancaster County for a number of years. And Judge Chevrant always said, and he was right, that we do the best we can, and there's an appellate court system in Nebraska that allows people to challenge what we say, whether we're right or wrong. And I think that's a very good system. But most important advice you can give to future attorneys: be prepared. It sounds so simple, and yet it is so hard. Nowadays, so many people are thrown into the courtrooms that have no idea what happens in a courtroom. I strongly urge attorneys to go to a courtroom and watch a proceeding before you first do it, to at least see how things are done. It's amazing to me the number of people that come into a courtroom who don't even know how, attorneys who come into a courtroom, who don't know how to offer an exhibit. I mean, I realize the day-to-day workings of a courtroom are different than academic law school classes. If you're in a clinic program, then you learn those types of things. Not everybody's in those programs, but there's no reason why people can't sit in the back of the room and watch how a proceeding takes place. Attorneys are advocates for their clients. That's the system. It's a good system. Being an advocate does not mean you should not be civil. Does not mean that you can't be courteous. Does not mean you can't be respectful. You can be all those things and still be an advocate. My experience in Lancaster County and in western Nebraska is that the vast majority of the attorneys with whom I practiced, against whom I practiced, and who I saw in my courtroom were able to do all those things. They were able to be respectful, courteous, civil, and at the same time advocate for their clients. It's sometimes a hard line. Sometimes emotions become involved. I think attorneys have to be very careful not to become emotionally bonded to their client's position, to where they lose sight of what their job is, and it is to, in my opinion, to espouse their client's position under all the rules that they're supposed to use in the courtroom. I think if they do that, I think they'll be very successful.